Two self-represented defendants walked into court believing they could handle their own cases, but the results could not have been more different. This time, we're following two courtroom battles that reveal just how high the stakes get when someone chooses to stand alone before a judge. First, we begin with Georgia driver Sydney Steele. On March 20, 2024, Lieutenant Jonathan Carey of the Clayton County Sheriff's Office cited her for allegedly following another car too closely and making an improper lane change. She pleaded not guilty on May 16, 2024, and her case was set for a bench trial, meaning the judge, not a jury, would decide the outcome. More than a year later, on August 27, 2025, that trial finally took place over Zoom in Clayton County State Court before Judge Tammy Hayward. What follows looks simple on the surface, but the details are where everything starts to shift.
Sydney Joy Steele, okay, you're charged with following too close on 2024 TK 06653. You're also charged with improper lane change on case 2024 TK 06652. Mr. Tipton, are you ready to go forward with trial?
Yes, Your Honor. State's going to call Lieutenant Jonathan Carey to the Zoom call.
All right. Lieutenant Carey, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right. You can put your hand down, sir. Ms. Steele, you understand that you have the right to ask questions of any witnesses brought by the state. The state has the burden of proving the case against you beyond a reasonable doubt. You do not have to give any testimony or evidence against yourself. You have a Fifth Amendment right against self-incrimination, and the state needs to prove the case beyond a reasonable doubt. All right? Do you understand?
Yes.
All right. Mr. Tipton, you may introduce your witness.
Yes, Your Honor. Lieutenant Carey, please state your name for the Zoom call.
Lieutenant Jonathan Carey.
And Lieutenant Carey, how are you currently employed?
Currently the lieutenant for the Clayton County Sheriff's Office, Black Hawk Traffic Unit.
And how long have you been with the Clayton County Sheriff's Office?
The Sheriff's Office, probably a little over 2 years.
Mm-hmm. And you have prior experience before that, correct?
Yes, I was with the Clayton County Police for about 4 or 5 years.
Okay. And during that time, both with the Sheriff's Office and the Police Department, have you been post-certified?
Yes.
Okay, and being post-certified, are you authorized to investigate crimes, issue citations, and make arrests based on your investigations?
Yes, I am.
So I want to bring your attention to March 20th of 2024. Were you working for the Clayton County Sheriff's Department at that time?
Yes.
And were you on duty that day?
Yes, I was.
Did you at any point in time have occasion to make contact or initiate a traffic stop with a white Chevrolet Trax that was driven by Miss Sydney Steele?
Yes.
Okay. Can you tell me about what drove you to, or what caused you to initiate contact with Ms. Steele?
Yes. So during my role during the day, I look for erratic lane changes, reckless drivers, speeders. So while traveling out on Bear Boulevard, passing over 88, I was monitoring traffic in my rearview mirror. I observed a white SUV changing several lanes, not giving the public enough notice that she was changing lanes, nor was she using a nor was the vehicle using a turn signal. I observed the vehicle getting closer to me as she was changing lanes. She was also following another vehicle too close. Once she changed from lanes 2 back to lane 1 several times, she passed me. I'm sorry, from lane 3 to lane 2, she passed me in lane 3. And that's when I conducted a traffic stop on that vehicle and spoke with the driver. While speaking with the driver, she advised that she was in a hurry to get to Atlanta because she had a hair appointment.
Okay. You say she didn't use any turn signals. Is that correct?
Correct.
Okay. And what was the basis of the following too close?
She was following another vehicle too close as she was changing lanes.
Based on your knowledge, your training, and your experience, as well as what you observed, was that a safe maneuver for her to make?
No, it was not.
Would a reasonably proven driver have followed that closely?
No. And if that vehicle in front of her would have slammed on the brakes, she would have been at fault, and that definitely probably would have caused an accident.
Okay. And with the improper lane change, was there anything improper? Tell me about what was improper about that lane change besides just the signal.
So when you change lanes, you have to give the public enough notice that you're about to change lanes, which she failed to do.
Okay.
Several times, not just one time.
Okay. So about how many lane changes did you observe?
I believe I observed 3. So she went from the number 3 lane to the number 2 lane, then back to the number 3 lane.
It's occur in Clayton County?
Yes, it did.
Okay. I have no further questions at this time.
All right, Ms. Steele, did you have any questions of Lieutenant Carey?
Yes.
Go ahead, ma'am.
So you said that you were observing me in your rearview mirror when I
Correct.
did all of these. Okay. So if you're observing me in my rearview mirror, how are you able to see how close I'm driving behind another car? If you're looking in your rearview mirror, you would see the car that's in front of me. You wouldn't be able to see my car.
I can see your car and the car in front of you.
Got you. So how are you able to determine how close my tires were to the trunk of the car in front of me?
I can't determine how close your tires are, but I can determine how close your bumper is to their rear bumper
And how are you able to do that?
by looking at it.
And what did you see? How close was I? If you had to guesstimate.
You're less than a car length behind them.
Less than a car length?
Correct.
And this was another car and this was not your car?
Correct.
Okay. I don't have any more questions for you.
Once the officer finishes testifying, Sydney gets her chance to cross-examine him, and that's where the pressure begins to build. He insists he could see both her vehicle and the car ahead of her through his mirror, and he estimates she was less than a car length behind. That matters, because under Georgia Code Section 4649, a driver can't follow another vehicle more closely than is reasonable and prudent given the speed, traffic, and road conditions. And in the 2009 case Proctor v. State, the Georgia Court of Appeals upheld a stop where an officer saw a driver traveling about 1 car length behind another vehicle on the interstate, concluding that a sudden brake could have caused a crash. In other words, if the judge believes this officer's version, his testimony could be enough to support the traffic charge. But that "if" is about to become the whole case.
All right, anything else, Mr. Tipton?
Briefly, Your Honor. Lieutenant Carey, was your view of the car immediately in front obstructed?
No.
Was your view of Miss Steele's vehicle obstructed?
No.
Which lane were you in, sir?
I was in the number 2 lane.
Okay. And which lane did you observe the vehicle in when it was following too close?
Number 3.
Okay. Would you say that?
No, well, when she was falling too close, she was in the number 2 lane as well.
Okay.
She went from number 3 lane to the number 2 lane, followed the car too close, and then switched back to the number 3 lane.
Okay. Was there were there multiple cars that she followed too close to, or just the one?
Just the one.
And so you had an unobstructed view of her front bumper and the rear bumper of the car immediately in front of her, correct?
Correct, by using my side mirror at the time.
Okay, awesome. Thank you. No further questions.
All right,
I do have just one more question.
go ahead.
What was the kind of car that I was driving behind?
I'm not sure.
Okay.
Then the testimony starts to wobble. On redirect, Lieutenant Carey shifts his description and says he used his side mirror to see the vehicles, even though he had previously said he observed them in his rearview mirror. Sydney follows up with a deceptively simple question. What kind of car was she supposedly following? He can't say. He doesn't remember the type. He doesn't remember the color. And that is exactly the kind of crack a self-represented defendant hopes to expose. By forcing him to admit those missing details, Sydney appears to be doing something very strategic. She's not just disputing the ticket, she's challenging the reliability of his memory itself. If his recollection is fuzzy on the most basic facts, the rest of his version suddenly becomes much harder to trust.
Do you remember the color?
No, I don't.
Okay. I don't have any more questions.
All right. Did the state have any additional witnesses to present?
No, Your Honor. State's going to rest at this time.
All right, Ms. Steele, did you wish to present evidence and testimony?
Yes.
All right, you understand that you're not required to present any evidence or testimony?
Yes.
All right, you're waiving your right to remain silent in order to offer evidence and testimony?
Yes, ma'am.
All right, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right, you can put your hand down. Go ahead, tell me what you need me to know.
Okay, so The day this happened, I stopped at the gas station. At the time, I was 6 months pregnant. I stopped at the gas station, grabbed some water. I get out of the gas station. I turn right. As soon as I turn right, I turn into a light. I pulled behind the police officer. No other car was in front of me other than the police officer. When the light changed, it's like he wasn't moving. So I put my signal on to get in the lane to the right of me. I got in the lane to the right of me. He then got in the lane behind me. And I looked in my rearview mirror and I'm like, he is driving so close to me. Like, he was so close. I could not see his tires. This is why I asked these questions, because in driver's training, they teach you have to at least be able to see the car's tires behind you. So that's how I was able to determine that he was driving too close to me. It was not a car length behind me. So then I'm like, okay. So I put my signal on, get back in the left lane. He gets back in the left lane. So I'm like, what is happening right now? Like, I was so confused as to what's happening. I'm like, am I in his way? What's going on? So then I did get back into the right lane. And when I went to get into the right lane, that's when he turned this light on and pulled me over. And I was confused as to, one, why he chose to do that. Because I was, like I said, I was just confused. And he asked me, I asked him, why did you pull me over? And he said, are you in a hurry or something like that? And I was like, well, I'm trying to get to my hair appointment because I was going to get my hair done for my baby shower. And he's like, okay, and then asked for my information. And when he came back and told me, one, driving too close, I'm like, how was I driving too close when I pulled up behind you at a red light? So I literally was not driving. You weren't driving. The light was red. And then when the light changed colors, you didn't really take off. So I'm like, okay, let me get out of this man's way because I have somewhere I have to go. And clearly he does not. So that's when I got over. And also, I have a 2024 Chevy Trax. My car, you literally cannot switch lanes without putting your signal on because it will jerk you back into your lane. So for one, I don't change lanes, especially while I was 6 months pregnant, without giving anybody proper notice because I wouldn't want to put myself or my son in danger. And then that's why I also asked, what was the car? Because, there literally was not another car in front of me other than him. And then when I got over, for him to see all of these different lane changes, he was right behind me. And I did switch lanes that many times because he was driving so close up on my bumper to where he was correct. If I would have put on my brakes, he would have hit me in the back of my car.
Okay. Any questions, Mr. Tipton?
No, Your Honor.
All right. Anything else, Ms. Steele?
No, ma'am. No, Your Honor.
Okay. Argument?
State will submit on the facts, Your Honor.
All right. Ms. Steele, I found you not guilty of the offenses before the court. Each of you are given testimony in this case. Each person has submitted sworn testimony without additional evidence. Neither testimony has greater weight than the other. Therefore, the court is not able to determine beyond a reasonable doubt that you committed an offense in this case and finds you not guilty on both offenses.
Thank you.
You're welcome.
After Sydney gives a completely different account under oath, Judge Hayward finds her not guilty on both charges. With no added evidence beyond the sworn testimony of two people telling sharply different stories, the court says it cannot conclude beyond a reasonable doubt that she committed either offense. And that brings us to a second defendant whose self-representation took a far more dangerous turn. On September 3, 2023, Trevor Emloud was charged in Michigan with operating a watercraft while intoxicated, a misdemeanor, and resisting or obstructing conservation officers, a felony. He was arraigned 2 days later, released on bond, and after a preliminary examination, the case was sent up to the 53rd Circuit Court and assigned to Judge Aaron Gotch. A pretrial hearing was set for December 19, 2023. Unlike Sydney, Trevor chose to represent himself in a case with much more serious consequences, and almost immediately, the hearing went off course.
Understand your right to a lawyer, including a court-appointed lawyer?
I understand that.
Okay. And do you wish to represent yourself instead of having an attorney?
Yeah, I'm here by special appearance, and I will be representing myself.
I'm required by law before I accept that waiver to do a couple things. One, advise you of the maximum penalties that you could face for the charges that you're in my court for. Resisting, obstructing conservation officers is a high court misdemeanor punishable by up to 2 years in prison and or $1,000 fine. There's a habitual offender second notice that's been filed by the prosecutor, which would make that a felony punishable by up to 3 years and or $1,000 fine. And marine safety operating while intoxicated is a misdemeanor punishable by up to 93 days and or $100 to $500 fine. Do you understand the maximum penalty for the charges against you?
Well, I don't even really understand why I'm here, honestly.
Well, okay. Well, that's fine. Do you understand the maximum penalty that I just explained to you?
No.
Hold on. I can't let you represent yourself until I establish a couple things.
Well, I need to establish a couple things too, honestly.
Hold on. Well, I can't let you represent yourself until I establish a couple things, or I'm going to be in trouble. Do you understand that the maximum penalty that you could face for the charges that you're here for is up to 3 years in prison and or $1,000 fine?
I don't understand the nature and cause of the action against me. So
what is it that you don't understand? Do you not understand how long 3 years is, or how much the fine is that I've articulated? Can you tell me what it is you don't understand?
I don't understand the nature and cause of the action against me because there's no established jurisdiction.
That's not what I'm asking you right now. Well, I'll let you place whatever objections you want on the record, Mr. McLeod. I promise you that. Okay. Can we just go one step at a time? So do you understand the maximum penalty that you could face if you're convicted as charged? 3 years in prison or $1,000 fine?
Well, I have another question because the statutory jurisdiction doesn't exist under the Constitution. So in order for me to defend myself, could you please tell me where the published rules of conduct are for criminal statutory jurisdiction, or where I can find the nature and cause of this jurisdiction, or how this information exists?
No, I don't even understand what you're asking.
So you're saying this is a statutory jurisdiction under what? The statutes of Michigan, correct?
Mr. McLeod, I've told you what my jurisdiction is.
General jurisdiction.
The people of the state of Michigan voted to convene a constitutional convention in 1961.
Sure.
There was a constitutional convention in 1961 and 1962. They proposed a state constitution. The voters of the state of Michigan ratified that in 1963. Article 6 establishes the judicial power. And the circuit court is a court under that judicial power of Article 6 of the state constitution. And so you're here in my court. I have subject matter jurisdiction over those crimes. I have personal jurisdiction over you because you've been alleged to have committed them in our county. That's my jurisdiction.
Trevor's central argument is that the court has no jurisdiction. In plain terms, he's claiming the judge has no legal authority to hear the case or issue binding rulings against him. Judge Gotch responds by laying out the foundation step by step. The Michigan Constitution, ratified in 1963, creates the judicial power under Article 6, and the circuit court derives its authority from that structure. That addresses subject matter jurisdiction, the court's power to hear this kind of criminal case. Then there's personal jurisdiction, meaning the court's authority over this particular defendant. Because Trevor is accused of committing the offenses within the court's geographic reach and was properly brought before it, that requirement is met too. So while Trevor keeps pressing the issue as though jurisdiction is still unresolved, the legal basis for the court's authority is already in place. The problem is that he's fighting a battle the law does not support, while ignoring the question that actually controls whether he can continue representing himself.
So, Mr. McLeod, you want to represent yourself? Do you understand the maximum penalty that you could face of 3 years in prison and or $1,000 fine?
One second.
I can see why his attorney would, Drew. Oh, shit.
Hang on. Someone in the prosecutor's office is not muted. I'm going to remove you from the meeting at this time.
Oh.
Prosecutor's office is generally allowed to attend to observe. They've participated. I'm removing them from the hearing. Mr. McLeod, do you understand the maximum penalty that you could face?
1 second. Okay, so in enforcement of mere statutes, judges of all courts do not act judicially and are thus are not protected and qualified by limited immunity. That's Owen versus the city. I just want to state a few things for the record since you're claiming this is a jurisdiction under statutory law.
Hang on. Mr. McLeod, can we back it? Look at me for a second. Can we talk here?
I've challenged subject matter jurisdiction and nothing can go forward until that's addressed. You're saying
I did address it and I denied your objection. I have subject matter jurisdiction.
Exists under the Constitution.
Your objection is noted. So, Mr. McLeod, do you understand? Let me explain to you.
Sure.
Sometimes, as I said, people might want to represent themselves, but let's say they have limited intellectual capacity and they don't understand what's going on. I have to establish that they know what's going on before I can allow them to represent themselves. I'm required to establish, do you comprehend, do you know the maximum penalty that you could face if you're convicted as a result of this charge? 3 years in prison or $1,000 fine. Do you understand that, Mr. McLeod?
So I'd like to state for the record that
Mr. McLeod, stop.
Court can be.
Stop, Mr. McLeod. If you don't understand it, I'm going to revoke your right to represent yourself and have an attorney represent you because I can't establish that you know what you're doing. So do you know the maximum penalty that you would face?
Judge Gotch keeps trying to pin down one basic point. Does Trevor understand the maximum penalty he could face if convicted? That question is not optional. Under the U.S. Supreme Court's 1975 decision in Ferretta v. California, a defendant has the right to represent himself only if he knowingly, intelligently, and voluntarily gives up the right to counsel. That means the judge must make sure the defendant truly understands what he is doing and the risks involved. In Michigan, law goes even further. In People v. Anderson, the Michigan Supreme Court explained that even when a defendant clearly wants to proceed without a lawyer, the court can still deny or revoke that right if self-representation would disrupt proceedings or burden the administration of justice. So before Trevor can argue the law, cite authorities, or challenge the charges, the judge first has to establish that his waiver of counsel is informed and valid. Trevor's refusal to answer that threshold question puts his entire strategy on a collision course with the courtroom itself.
Your Honor, I've challenged this court's jurisdiction. You haven't established it yet. You said you have a statutory jurisdiction which doesn't exist under the Constitution. I'm trying to figure out where I stand with this. So I can't answer any of your questions until you answer some of mine.
That's not how it works. Are you refusing to answer my question?
No, I'm
Then answer it. Do you understand the maximum penalty that you face for this charge?
So judges who become involved in enforcement of
Mr.
these
McLeod,
statutes,
I have other matters. Mr. McLeod,
agency.
you know, I understand you want to object to things, and you're going to be allowed to object to things, okay?
Sure.
But we have to do things one step at a time. And I do have other cases today. I'm not going to entertain this for like a whole hour. I've got other cases going on. If you want to dig in your heels and just make this real complicated or real difficult, we could do that. And I can hold you in contempt and you'll go back to a jail cell for a while.
I don't wish to be held in contempt. I just wish to exercise my Sixth Amendment right.
That's fine.
And
so before I can let you under,
I can cite laws that will show you that the exercise of a right can be converted into a crime. I'm trying to understand the nature and cause of the action against me. You're not clarifying enough to where I can comprehend it, as you say.
You don't comprehend the maximum penalty that you would face.
I'm not answering any of those questions until you establish that this is a court of the Constitution, has jurisdiction under these jurisdictions.
I established it. I told you. You might think I'm wrong, and you can appeal.
There's no such thing as a statutory jurisdiction.
Mr. McLeod, let me make this simple for you. Do you ever watch? Let me make this simple for you.
Sure.
I'm going to ask you this question one more time. One more time.
Okay.
Two things are going to happen. You are either going to answer my question, or I'm going to hold you summarily in contempt, and the court officer will bring you to a jail cell, and we'll talk about it tomorrow. You understand that?
So,
Mr. McLeod, two things are going to happen. You're going to answer my question, or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine?
I don't understand the charges.
Mr. McLeod is in contempt of court, taken into custody.
Really? That's it. Protecting my rights is what you said last time. This isn't true. You guys are
follow unconstitutional orders.
Following unlawful orders. It's not constitutional at all.
Mr. McLeod's in contempt, he's sentenced to 1 day. Mr. McLeod, your sentence is 1 day in jail. We'll reconvene tomorrow and get you
This
notice.
is about the Constitution. I did nothing wrong except to question and exercise my rights.
After Trevor refuses again and again to answer the judge's question, Judge Gotch holds him in contempt and sentences him to 1 day in jail. But the unraveling doesn't stop there. As the case continues, Trevor remains self-represented for a time and becomes even more disruptive. In July 2024, Judge Gotch revokes both his right to represent himself and his bond after he refuses court mail and fails to appear for a scheduled hearing. By September 2024, the case ends with Trevor pleading guilty to 1 felony count of resisting and obstructing a conservation officer and 1 misdemeanor count of operating a vessel while impaired. He receives a sentence of 69 days in jail with full credit for time served, along with a fine and a 12-month suspension of his boating privileges. Placed side by side, these 2 cases tell a brutal truth about self-representation. Sydney Steele came in focused, composed, and anchored to the facts. She understood the allegations, respected the procedure, and used careful questioning to expose weaknesses in the officer's testimony. Trevor M. Loud took the opposite path. Faced with more serious charges, he turned the hearing into a fight over the court's legitimacy, refused to answer foundational questions, and repeatedly disrupted the process. One defendant built credibility and walked away with a favorable verdict. The other lost control of the courtroom and eventually lost control of his own defense. That's the real lesson here. The right to represent yourself is powerful, but it is not magic. Confidence alone is not enough. To use that right effectively, a person needs preparation, discipline, and a working understanding of the rules that govern the room. Sydney's case shows that, in the right circumstances, a self-represented defendant can absolutely succeed, especially in a lower-stakes traffic matter. Trevor's case shows how fast everything can collapse when those fundamentals are missing. If there's another courtroom clash worth breaking down, leave it in the comments. Thanks for watching.